Hello and welcome to today's WorkSafe Month webinar, COVID-19, Employees' Legal Obligations under the Tasmanian Anti-Discrimination Act 1998 is non-negotiable. I'm Stephanie Morawski from WorkSafe Tasmania and I will be your moderator. Before we start, please take a moment to read the following slide about information received today. I will now go over housekeeping. Here is a screenshot of the attendee control panel. You should see something that looks like this on the right hand of your screen. You're likely listening in using your computer speaker system by default. If you would prefer to join over the phone, just select telephone in the audio pane and the dial-in information will be displayed. Webcams and audience microphones will not be used in today's webinar. Please use the questions pane on your control panel to type and submit your questions, which will be taken at the end of today's webinar. There are also handouts available for you to download now. These are available in your handouts pane and will be referred to during the webinar. Finally, today's webinar is being recorded. I would now like to introduce your presenter, Jennie Gorringe, Senior Trainer with Equal Opportunity Tasmania. Jennie has been the Senior Trainer at Equal Opportunity Tasmania for the last 3 years. She was previously a trainer with the Tasmanian Health Service, delivering training to the community and staff in regional and remote health settings on health promotion practice and chronic disease management. Jennie has worked in women's health and local government as a community development officer. For 10 years, Jennie has also worked as a family violence worker in women's refuges in Tasmania and New South Wales. Welcome, Jennie.
Thank you, Stephanie. So welcome everybody. Just trying to get my slide to go through. The slides are not coming through right now. Oh, yes, they are. Whoops, back again. So welcome everybody to the webinar on COVID-19, employers' legal obligations under the Tasmanian Anti-Discrimination Act is non-negotiable. When it comes to COVID-19, it's about taking a balanced approach by employers, assessing risks versus avoiding non-compliance. It requires HR to be balanced and consistent and to understand their obligations and how to deal with a fast-changing workplace environment. The COVID-19 situation changes rapidly, as we have seen over the last 7 months. It has raised unprecedented issues for employees and employers across Australia. In Tasmania, we've experienced lockdown to working in our own island bubble. Being aware and consistent in our policies and processes regarding COVID safety plans, and most importantly, consistent communication to staff across our businesses and organisations are essential. Oops. The Anti-Discrimination Act makes discrimination offensive or humiliating conduct such as sexual harassment, inciting hatred and victimisation are all unlawful. It's reminding us that discrimination is against the law. COVID has exposed a number of areas in which discrimination has escalated, in particular the attributes of age, race, disability, gender and family responsibilities. Obeying anti-discrimination issues is not a choice. Employers have a legal obligation under the Tasmanian Anti-Discrimination Act to take reasonable steps to create a workplace that is free from discrimination and other prohibited conduct. Section 104 of the Anti-Discrimination Act states that organisations must make sure all members, officers, employees, agents, this includes volunteers, interns and contractors, are aware of the discrimination and prohibited conduct to which the Act relates. Organisations must take reasonable steps. This would include effective policies and procedures such as your code of conduct, your grievance procedure, also having training on discrimination and harassment and other inappropriate conduct. An organisation that does not comply with Section 104 is liable for breaches of the Anti-Discrimination Act. The key is don't be complacent. Ensure policies and procedures are up to date and are accessible online. Hard copies are available to staff. Ensure that managers and supervisors have regular team meetings and toolbox meetings, making sure there is a conversation around understanding your code of conduct, your values of your business or organisation. What do we mean by discrimination? What do we mean by respectful behaviour? It's these values that we need to keep speaking about in this time of COVID. HR is there to give advice and support to managers, supervisors. This is so important because this is very complex at this time due to COVID-19. COVID has exposed our vulnerabilities. Make sure your business organisation is COVID compliant regarding work health and safety. Communication on your organisation or business response to COVID with all staff, making sure that managers and supervisors are actively sharing information, checking in with staff if they're working from home regularly. This means by phone, this means by Zoom or MS Teams. Again, making sure that this is done on a regular basis. Work with staff if there have been downturns in business by engaging with staff to manage your business operation and requirements. Don't leave people in the dark because they'll make up stories about where the business is going to go to into the future. Importantly, workplace culture. Talk about what respect means. Don't just put it up as a value. Unpack it. What does it mean for individuals? Because we're all different. Really looking at those issues around empathy because COVID has really stressed people out. We know that people's mental health and well-being is at a precedently high level at this moment in time. Making sure people use respectful language and behaviour, because what we've seen with COVID is that it really has brought out people's stereotypes around race and age, and making sure that there's about combating misinformation regarding COVID. Doesn't matter if you're a small or big business, good compliance regarding COVID work health safety plans are essential. This means information and advice given by public health is the advice that we follow and act upon, not your own personal opinion. We have 22 attributes under the Tasmanian Anti-Discrimination Act, and COVID has exposed a number of areas in which discrimination has escalated, in particular the attributes of age, race, disability, gender, and family responsibilities. What we mean is unlawful discrimination means it's unlawful to discriminate against people on the basis of particular characteristics, protected attributes. It can be direct discrimination if a person treats another person on the basis of a protected attribute less favourably than a person without that attribute characteristic, such as race, gender, age. It could be indirect discrimination when a condition, requirement or practice which is unreasonable and disadvantages the person. Examples of unlawful discrimination and prohibited conduct during the COVID times: making racist comments towards people because of their race. Race includes a person's skin colour, nationality, ethnic background and immigrant status. Reducing someone's hours or terminating someone's employment because they have COVID-19, or caring for a child or a relative who is in isolation or who has COVID-19. Depending on medical advice, not allowing an employee to work from home who is older or vulnerable to COVID-19 because of their health, or because maybe they are of Aboriginal or Torres Strait Islander background. When we talk about disability, it breaks it down into, this includes areas such as intellectual and physical disability, mental health from anxiety to depression, to long-term health conditions or injuries, and COVID could could possibly sit in there. Again, this is an important part to remember. Irrelevant medical record, the use of any information in a medical record that is not specifically relevant to circumstances could result in unlawful discrimination. This could be an issue with COVID-19, especially for older workers and Aboriginal and Torres Strait Islander staff, where discriminatory practices regarding someone's health status could be used unlawfully. This means a pre-employment medical test should be designed to test only a candidate's capacity to complete the requirement of the job. Family responsibilities. It is discrimination based on family responsibility when a person is treated unfairly or is denied the same opportunities as others because they require to care for a family member, child, immediate family member, partner, sister, brother, maybe even a grandparent or a child or adult child with a disability. Related conduct that is unlawful or prohibited conduct. It is unlawful to offend, humiliate, intimidate, insult, or ridicule on the basis of specific attributes, a person or a group of people. It's based on the reasonable person test. The behaviour or conduct can take any form such as gestures, actions, speaking, writing, displaying messages. This also can include social media, and we've certainly seen an uptake in a lot of discriminative language on social media since COVID-19 has come about. Sexual harassment is unwelcome and unwanted. It can be jokes, comments, it can be on social media as well. Inciting hatred, a public act that humiliates, intimidates, or insults or ridicules. Anyone who publicly encourages others to hate another person or a group of people because of their particular characteristics may be breaking the law. Public acts are those actions other people can hear or see, and including displaying, sending out information such as leaflets, billboards, and comments on radio, television, or social media. Again, we've seen an uptake on racial vilification specifically, which has been broadcast on radio and television, as well as social media as well. But we have seen a rise in around disrespectful behaviours in workplaces regarding naming out people because of their racial background and COVID. Again, victimisation, threatening a person or harming them because, for example, they have made a complaint or are going to complain, have complained about behaviour that would be unlawful under the Act, are a witness or supporting someone to put in a complaint, are accused of doing something unlawful. Causing, aiding, must knowingly cause another person to contravene the Act. Advertising or promoting discrimination or prohibited conduct. Discrimination law states you may not publish or display any material, including an advertisement that promotes, expresses, or depicts discrimination or unlawful behaviour. Self-awareness, it is about us recognising our own personal bias, and this is a very important one when we're interacting with staff. It could be maybe people who are also volunteer staff in our organisation. It's all about awareness. And one of the things that we're seeing with COVID, there's a real chance that employees may panic or overreact. They may say they won't come to work because they're worried about getting the virus, which is effectively a work refusal. While employees have a right to refuse unsafe work, it has to be based on a reasonable assessment of the risks. But given how hard this threat has hit all of us, employers may not want to move directly to discipline. Instead, they might want to say, you can take an unpaid leave of absence if you don't want to work. Managing workers' fears and concerns is a big part of this. Avoiding panic and dealing with each situation. Employees are scared and employers need to work with them, but to be open and honest about the situation. And, you know, that could be that HR, as HR people, that you need to be working more directly with your managers and supervisors to make sure that they know how to manage these individual situations with staff. It is about recognising stereotypes and prejudice and discrimination, and about how that bias really kicks in. We see this a lot in recruitment. We can see bias really plays a factor with how, for people with disability, we've certainly with COVID have seen a rise in discrimination for people over 50 and especially women. We've certainly seen for Aboriginal and Torres Strait Islander employees that there has been discrimination, partly based on the general belief that every Aboriginal and Torres Strait Islander person has got a chronic health condition, which is not the case. But again, it is about how bias can affect how we work and support people. So stereotypes, we're not born with stereotypes. We learn them. We learn them from our family, our workplaces, our education, all of those things. It's a belief. It's about having a stereotype about what somebody looks like, how they behave, their abilities. And prejudice is about a prejudgment. It's about having a prejudged feelings that could be positive or negative. Discrimination, specifically how that fits with under the Act, less favourable treatment as a result of that group or membership. So it is about treating someone less favourably based on that attribute. So got a few little kind of questions around COVID. Can an employer ask for a medical clearance before employees return to work? So these have been lots of issues that have been coming up in workplaces across Tasmania and across Australia as well. Employees must follow lawful and reasonable directions of their employer. Additionally, both employees and employers have an obligation to take reasonable care of their own and their co-workers' health and safety. A direction that an employee needs to get medical clearance before returning to work may be lawful and reasonable if it is designed to protect the employee or co-workers' health and safety in the workplace. There is also another part of it. However, if an employer directs the employee to pay for the medical examination in circumstances where the employee feels that they're fit to work and they do not need to self-isolate according to the Australian government rules or the public health advice in Tasmania, then the employer's direction may not be reasonable. So again, we need to be re-looking at that risk all the time. You can get further information about this from the Fair Work Ombudsman or Job Watch, which is based in Victoria, which is a really great place to get further information. The employee wants all employees to resume working from their workplace, but the employee would prefer to work from home. Now, this has come up a lot. Again, it's about, are we using a bias? Are we using a fair and reasonable process? So again, as HR managers and managers must consider where it's reasonably practical and equitable for their employees to work from home on either a partial or full-time basis. Decisions must be made in a fair and equitable manner, balancing the operational needs of the output with the health and safety of employees. Managers must consider the possibility of rotational arrangements to minimise the number of staff at work at any given time, but also give employees working from home a regular connection back into the workplace. All employees working from home must complete the working from home COVID agreement. It's all about diligence. It's asking the right questions, staying on top of things. It's no different than any other hazard in the workplace. What obligations does an employer have to keep an employee safe from COVID-19? employers have a duty to provide and maintain, so far as reasonably practical, a working environment that is safe and without risk to health of employees. This includes preventing risk to health, including psychological health and safety associated with potential exposure to COVID-19. Where a risk to health is identified at a workplace, employers must, so far as reasonably practical, eliminate or reduce the risk. Employers also have a duty to consult with employees and health and safety representatives. What if an employee is immune compromised? If an employee would prefer to avoid their usual workplace because they have reduced immunity, they can try to negotiate with their employer to come to an agreement about where they should work. When we talk about respect, within the context of COVID, it is about making sure that we have respectful workplaces, respectful communication within the workplace, making sure that it's a two-way street, that it's from the top down and the bottom up, that people are aware what's expected. A respectful language is very important in this time of COVID because there are a lot of stereotypes and prejudgments that are coming towards people, specifically people from culturally and linguistically diverse backgrounds, people with disability, older people, Aboriginal and Torres Strait Islander people. Again, making sure that our workplaces really unpack respect and what we mean by language. And teamwork is about how we work together as a group, but also supporting each other, because we know at this moment in time that that COVID has caused a lot of mental health and wellbeing issues for staff and businesses across Tasmania. So the main standards to resolving complaints, which is really important for all of us to really think about, is those things about treating all matters seriously, no bias, natural justice, making sure that we use a process that is fair for all people involved, and confidentiality and transparency is also important in that context as well. So one of the things I'd just like to say is that we provide face-to-face training and online training. We can tailor our training to your needs. We can travel around Tasmania. We're really happy to do that. We can also provide training online. There's our website address there, www.equalopportunity.tas.gov.au. We also have an inquiry line that you can contact between 9 and 5 Monday to Friday, where we can't give you advice, but we possibly can give you information if you're seeking specific information around COVID issues or any general discrimination issues. So there's the 1300 number. So thank you.
All right, thank you, Jenny. So we'll now take questions from the audience. So please use your questions pane to type and submit your questions. And just to remind everyone as well, there are handouts available in the handouts pane. So if you would like to take those handouts with you away after today's presentation, if you haven't downloaded them, please do so now. So a question that has come through, Jenny, if the organisation is not doing enough, what government regulators can we lodge a complaint with?
I would say that the first place would be contacting WorkSafe Tasmania. It could be if they're especially around those work health and safety risks that are happening in your workplace, that would be a place for that to actually happen, because there could be further investigations that WorkSafe Tasmania may do on that.
Thanks, Jenny. Another question, how important is it to keep notes when an issue is occurring at work?
I think I'm not quite sure what that question means. If you are an HR person who is, speaking to a staff member, I think, again, it has to be clear and upfront with the staff member that there may be notes that you're keeping for your own, own information about the discussion that's been happening. Also, possibly it needs to be shared, that information that you are writing down, if it is around specific workplace issues, that it needs to be made sure that that document is available to that individual as well. There are different ways, depending if it is a more formal investigation. Obviously, that's a different process in that time. If you're a contact officer, for instance, we encourage contact officers not to, your role isn't to scrutinise the individual staff member who's coming there. It's not an HR area, it's more for that staff member who's getting information about a possible issue with a grievance that they may have. So that's different in that context. But depending and making sure people are aware, if it is a workplace issue, that people are aware that you may be taking notes for a reminder for yourself for further discussion into the future, but depending on the situation.
All right, thanks, Jenny. You spoke about work from home and COVID-19 regarding staff working from home. Where can further information be found?
Probably one of the things around flexible working arrangement is around who can actually have that, and probably under the Fair Work Act, and ringing Fair or contacting or looking online through the Fair Work Commission around those different arrangements, because some of the things under the Fair Work Act, you have to complete at least 12 months of continuous service with your employer. If you're a casual employee, you must have worked on a regular and systematic basis, and you must have reasonable expectations of ongoing employment. Your employer may only refuse the request on reasonable business grounds, so it is good for the employer to actually seek further clarification on that under the Fair Work Act. The employer must respond in writing to requests for flexible working arrangements within 21 days. If the employer refuses the request, the employer must include reasons for the refusal. The employer cannot refuse unless there are reasonable business grounds. If there is a dispute about whether there are reasonable business grounds for the refusal, that can be lodged with the Fair Work Commission. Employees can also report alleged breaches of these provisions to the Fair Work Ombudsman. So there are a range of areas, but I would certainly encourage you to go look at the Fair Work Act, look on the Fair Work Commission. You can actually ring up and get advice as well. Obviously, for private versus public business, there's been a lot of different things that have occurred. Say within the state service, there were very clear directions from the Secretary, Jennie Gale, about how state public servants would be operating. Again, in private business, it's really important for employers and HR and management to be up to date with what is required, and some of it could be that there may be a government direction that everybody has to work from home. So what we've seen in Victoria, what we saw when we had that initial lockdown in March, that was a government directive through the public health. So again, we need to look at the reasonableness, because what we saw, that there was a lot of people who didn't necessarily need to be in the workplace, but there's different things for different areas, obviously, with our emergency service personnel and medical services, and in those type of areas, or in working in refuges or working in aged care facilities. So again, it's keeping up to date with the changes that happen with that.
Thanks, Jenny. Can I get you to comment on the following statement that's come through, or comment, yeah, the statement I should say. So I gather all of the equal opportunities and non-discrimination activities are only related to work and non-communication via social media such as Facebook.
Oh, okay. Can you, I think of what that person is possibly asking me is where discrimination actually, what does it cover? So under the Tasmanian Anti-Discrimination Act, it covers off on workplaces as well as sporting groups. It covers off on using services and facilities, say like hospitals, or it could be that you're in a public place in a shopping centre. You know, the Act actually covers every facets of our life, really. It's not just work. What was the other part of the question?
So in regards to social media.
And so, yes, we do cover off on social media, especially around those areas around humiliating and insulting and ridiculing someone, and especially inciting a public act. They are specific to specific attributes. So inciting hatred is covers off on the attributes of race, disability, sexual orientation, lawful sexual activity, religious belief or affiliation, gender identity, and intersex variations of sex characteristics. Like when we're looking at issues around prohibited conduct around which humiliates, intimidates, insults, that's based on the first 14 attributes of race and disability. So under each of those, social media does focus very heavily. I was just listening on the radio when I came in to work here today regarding some of the councillors in local government getting a lot of abuse through social media. Now, possibly some of those things could mean on social media that they may want to look more at are they a criminal matter? It could be that they need to lodge a complaint into us, the Anti-Discrimination Commission, because what the Commissioner would look at, has that been based on maybe your attributes such as your age or your gender, and there's certainly some of those things on the social media have been specifically focused at somebody's gender. It would also be looking about, you know, had that been that kind of direct or indirect discrimination as well. We do get a lot of complaints around social media, and a lot of the times the Commissioner, especially if there's been things like for job advertisements, will make sure that the social media company who is doing that takes it down. It's sometimes very hard to trace where exactly some of that information has come from, but it's about getting that information down and off social media is one of the main things to do.
All right, thanks, Jenny. Another question, recent government advice regarding allergies is even if a worker is convinced it is their normal allergy symptoms, they should have a COVID test. This could mean they are isolated at home 3 out of 5 days a week. Can an employer make this happen, or can an employee refuse?
That's an interesting one. I would say, depending on some of the information that we're getting from public health, is it reasonable around looking at the reasonability of how that may be linked to COVID-19? Again, I would be cautious about making sure that the staff member is supported if there were concerns with that, because we have been advised if we are having any symptoms, if we are feeling sick, that we go and get COVID tested. I mean, that's the best advice that we're getting from public health in Tasmania, but also nationally and internationally, is around, being tested. If that means that somebody does need to be in isolation for that 14 days for that, then that should be taken into account. But of course, when you get that COVID testing in Tasmania, turnaround I think it's within 24 hours that we're getting those testing results, that people can be made assured that they're COVID negative. Again, those other issues to do with their medical issues may need to be addressed within further investigation.
Thank you, Jenny. And a final question: if a whole department is made up of women and the majority of the staff are casual, could that be considered discrimination?
Well, well, I suppose this is one of the things that COVID, which we knew before, is that we have an extremely casualised workforce across Australia, and there's part of those reasonings have been possibly for businesses that it is depending on the business, it may be the better way that possibly that it does work. We've seen a lot of negativity with a casualised workforce, especially in the health and human services area, regarding that most casuals are working 3 and 4 jobs. We've certainly saw in Victoria, New South Wales and Tasmania that was one of the issues that came up with the spread of COVID on the northwest coast, was that there were people working in multiple facilities. Partly that was due to having a casualised workforce and those people making up their wages by working 3 or 4 jobs. Now it can be said, and if you went to the Australian Human Rights Commission and looked at a number of reports that are coming through, especially through the Sex Discrimination Commissioner, Sue Jenkins, that a lot of the casualisation has been very discriminative towards women, and having that casualised workforce means that people don't have protection in their jobs. We've seen that the universities across Australia have got a very casualised workforce, of which we've seen huge issues coming up with that. Now, it could, unless people want to take up this as, it needs to be discussed further in the Australian population about, do people see casualisation of employment the best option for people? And I would say that most people would say that it's not a great option. It should be an option, but it's not the way to necessarily fulfill and be a safety gap and to have a career for people into the future. So yes, there is, I don't know if you would be able to put in a complaint of discrimination in the context of about being discriminated against because of your gender on casualisation, but possibly in that broader context around looking at the casualisation of workforces, which has definitely affected women, it's definitely affected young people, and it's definitely affected people over 50. So yes, there has been a major issue with that.
All right, thanks, Jenny. So we'll wrap up the webinar now. So thank you, Jennie Gorringe, Senior Trainer with Equal Opportunity Tasmania, and thank you everyone for attending today's webinar, COVID-19, Employers' Legal Obligations under the Tasmanian Anti-Discrimination Act 1998 is non-negotiable. Once you leave today's webinar, you will receive a survey on the presentation. We would appreciate you providing your feedback. Certificates for webinars run throughout WorkSafe month will also be sent to attendees a day after they have attended. Today's webinar has also been recorded and will be made available at the end of WorkSafe month. On behalf of WorkSafe Tasmania and the WorkCover Tasmania board, thank you for joining us. Thank you, Jennie.
Thank you.